On Monday, October 30th, the House of Commons Standing Committee on Justice and Human Rights met to continue its discussions over the bill to amend the Criminal Code. The BC Humanist Association last week submitted our brief to the committee setting out why we support the government's decision to repeal sections 296 and 176, which prohibit blasphemous libel and disrupting a religious service, respectively. In this recording from the committee, Greg Oliver, president of the Canadian Secular Alliance, testifies before the committee with arguments largely similar to our own. In questions from MPs, he's also joined by Janet Epp Buckingham, a professor at the Laurentian Leadership Centre at Trinity Western University, and Cardinal Thomas Collins, Bishop Lionel, Gendron, and Bruce F. Simpson from the Canadian Conference of Catholic Bishops. To read our submission and to find out how you can support our efforts to repeal Canada's blasphemy law, visit bchumanist.ca.
Now to the Canadian Secular Alliance, Mr. Oliver.
Thank you. So, my name is Greg Oliver, and I'm here on behalf of the Canadian Secular Alliance. Thank you so much for the opportunity to speak today. The Canadian Secular Alliance is a nonpartisan and registered not-for-profit organization whose objective is to promote separation of religion and state in Canada. We strongly believe that to maintain equality between citizens in a pluralistic society like ours requires government neutrality in matters of religion, not favoring one religion over another, or favoring religion over no religion, or vice versa. This is one of the core principles of all liberal democracies. Fortunately, Canada has done a much better job of this than most countries in the world, but there's still room for improvement. In June of last year, I initiated the now certified petition E382, calling on the government to repeal Section 296, prohibiting blasphemous libel from the Criminal Code. There are several reasons why we feel this is necessary. First of all, freedom of speech is a core principle of every liberal democracy and a cherished right here in Canada. All ideas should be subject to debate, criticism, or even ridicule. Exempting religious ideas substantially erodes this principle. Also, Section 296 is no longer relevant to Canadian society. Its repeal would have strong support across the Canadian political spectrum, hasn't resulted in a successful prosecution in over 80 years, and no charges have been laid in over 35. Though I'm no legal expert, it is widely believed that it would be ruled unconstitutional under the Charter. If a law has not been used in decades or is most likely unconstitutional, it ought to be repealed, in our opinion. Another consideration is global affairs. Blasphemy is still illegal in 71 countries and is punishable by death in at least 6. Blasphemy laws are disproportionately used to persecute religious minorities and government critics. And there have been a variety of high-profile blasphemy cases recently. Asia Bibi in Pakistan, in Indonesia, former Jakarta Governor Ahok, Nahed Hattar in Jordan, Pussy Riot and others in Russia, and Raif Badawi in Saudi Arabia, and countless others who have not received international press. Each of these cases constitutes grave human rights violations by liberal democratic standards. And there may come a time when the elected representatives of this country wish to condemn cases like this. As long as we have blasphemy laws of our own, it significantly erodes our moral credibility when doing so. Our passive blasphemy law adds credibility to active and sometimes lethal blasphemy laws worldwide. We also support the proposal to repeal Section 176. Subsection 1 prohibits obstruction, violence, or arrest of clergymen. Now, the wording here, as has been noted, appears to apply only to male Christian officiants. This privileges men over women and Christians over those from other religions or the non-religious community. And harassment and assault laws already exist. To our knowledge, Canada is not burdened with a unique set of circumstances in which male or Christian officiants require additional protection from harm. Subsections 2 and 3 are concerned with disruptions to meetings for religious worship or for a moral, social, or benevolent purpose. Some types of meetings, such as weddings or funerals, can plausibly be interpreted in a religiously neutral manner. But we remain concerned about a chilling effect on freedom of expression at meetings for religious worship. There have been several cases invoking these subsections since the 1980s. One of the cases that caught our eye was Stoke Graham versus the Queen from 1985. In this case, a Nova Scotia Catholic Church changed how congregants were expected to take communion. Instead of kneeling, they would now stand to receive it. 6 congregants dissented from this decision and continued to kneel when it came time to receive communion. Eventually, when presented with an ultimatum to stand, they refused to take the communion and they returned to their seats. Now, they were convicted under Section 176, and it was upheld twice on appeal, but the charges were overturned at the Supreme Court. Now, in this case, the short and passive nature of the protest exonerated the accused, albeit in the highest court in the country, but it highlights our concern that Section 176 protects religious dogma or orthodoxy from criticism or civil protest. There are a myriad of religious ideas or practices that some may find objectionable. This is relevant within religious communities as well as outside of them. We remain unconvinced that these meetings are always an inappropriate venue for expressing differences that arouse controversy and therefore are requiring more protection under the law. Having said that, we of course acknowledge the benefit to society of protecting against certain destructive acts at these meetings. But as the minister and several others have already articulated, the criminal code already criminalizes causing a disturbance, uttering threats, intimidation, and incitement of hatred towards identifiable groups. Sentencing is typically more severe when the offense is motivated by hate towards religious communities, and hate crime laws are potentially applicable as well. In our view, these protections make Section 176 unnecessary. Thank you.
Thank you very much to all 3 groups for your testimony. And now we're going to go to questions. Mr. Nicholson?
Thank you very much, and thank you very much for your testimony here today. Mr. Oliver, you said that your understanding of this Section 176 is that it's for the protection of Christian males. You may be aware, or maybe you're not aware, that the interpretation, including the courts and the government, Revenue Canada, National Defence, and everything, is that it includes all religious officials, regardless of their sex or their religion. Were you aware of that?
No, but it's a good argument for cleaning up the wording if it were to be retained in any way, shape, or form. And I would add, perhaps you could answer this question for me. Does it apply to secular humanist officiants as well?
I'm asking the questions here today, Mr.
Oh, okay.
Oliver. As far as I know, you know what I mean. But thank you for that. I'll take that under consideration.
Well, our primary concern, of course, is that it is religiously neutral.
Yeah.
And under the current wording, it's certainly plausible that you would interpret it in a different way.
Could be. Thank you, Professor Buckingham. That was very well put together, your explanation of this and your rationale, and it actually coincides, with my own thoughts on this. I mean, one of the interesting things, and we've heard this before, is that if something hasn't been used very often, therefore it should be taken out of the criminal code. I was saying to some of my colleagues, I remember at law school them talking about the treason sections of the criminal code, and they were saying it's not used very often. So I hope that nobody would then make the conclusion, we better get rid of treason out of the criminal code just because Canadians don't commit some of these offenses. But thank you for that. Your Excellency, Cardinal, could you, and both are bishops that are here today, and Mr. Simpson, it's important to get this word out as to what's actually taking place. We've heard testimony that, in fact, just earlier today, that you may have heard or seen that this took a lot of people by surprise, that, quite frankly, there wasn't much publicity for this. It just got dropped out in the summer. What can be done? What do you think are you going to do to get this message out before this bill actually comes down to third reading here, to get that message out? Are you distributing it to parishes, letting them know? Because I think that seems to be an essential part of this, to make sure everybody knows exactly what's going on. Cardinal Collins?
Okay, well, I think that it might very well be important. The very publication of this meeting makes people more aware of that. I think it is. There may well be some plans on behalf of the Canadian Conference of Catholic Bishops, and I would suggest maybe Bishop Gendron might have some insights into that, which covers this is responsible for the whole country.
Je dirais que moi-même, je n'étais pas tellement.
Well, I was not aware of that, really. It was the staff who woke up to the reality, and since May, we've been working on this issue. We drafted this brief. How will this affect parishioners? How will parishioners get this information? Well, the media will convey what is happening. This committee will reach them, and so they will better understand what is underway. So for reasons which are different, I would say that Professor Buckingham talked about hate crime cases, and there are more and more of those here in Canada. I fear that if we remove that section, I fear the message Parliament would be sending to Canadians. There is possibly a pedagogical interest in keeping Section 176.
Your role as a solicitor for the Catholic Conference of Bishops and your work in the legal profession, would you agree that it's not just only hatred that might motivate somebody to disrupt a religious service? There are those who may think this is some sort of comical effort, but it would be completely included in this. And would you agree as well that the worry that somehow the old wording of this is only restricted to male members of the Christian faith is your experience with the law that generally the courts look at a larger context and expand the definitions?
Yeah, I'll start with the second part first, if you don't mind. Excuse me. I don't see how you can really interpret clergymen as meaning anything other than a religious leader, regardless of their gender and regardless of their religion. And it's important to note the courts have said over and over again that when interpreting legislation, you should try. You can't bend the words all out of shape, but if there's a reasonable interpretation consistent with the Charter, that's the interpretation you go with. If clergyman only means a male Christian, this can't stand constitutional muster. But the Supreme Court of Canada and the British Columbia Court of Appeal have said it does. Now, admittedly, they weren't dealing with that particular issue, but it would have hit them in the... I mean, anybody can read it. So I really think that's the thing. The other point here, I think that's important, the hate crimes, you can disrupt a religious service motivated by what isn't really hate. And I think my friend... Mr. Oliver makes a good point in one way. There's a difference between expressing strong feelings against, say, a religious doctrine and strong feelings against members of a congregation. My understanding is that the one is legal and probably should be, the other is not and shouldn't be. But it doesn't matter what the motivation is, I don't think. If you're disrupting a religious service, you're causing a great deal of emotional turmoil to a large number of people. And I don't think it matters why they're doing it. They're doing it. I think it's also important. Somebody made the point about a lot of these cases get diverted. Well, that's because when there's mental illness, often courts decide to divert if the person will get the treatment they need. And the Crowns are involved in that. But without the charge being laid, there's often no mechanism for that. The same is true of things like restorative justice, which a lot of churches are very much on side with, but often you need the charge to get that process in motion. So, and I would point out, if you look at subsections 2 and 3, they're not covered by Section 175. There are lots of ways to disrupt a religious service without violating 175. And
thank you very much. Mr. Sassy?
Thank you. Mr. Chair. Now, if I could ask Mr. Oliver a few questions. Thank you ever so much for appearing before this committee, Mr. Oliver. My first question is, as you know, the freedom of expression is closely derived from other freedoms, such as freedom of expression, freedom of assembly, and freedom of conscience. In your opinion, is the repeal of blasphemous libel, will it strengthen and fortify those other freedoms?
Well, of course. I mean, freedom of speech is essentially the best corrective we possess as a species for making progress in whatever realm that may be: technological, scientific, ethical, philosophical. And some of the issues that religion tackles are some of the most important philosophical questions that are facing mankind. Where do we come from? Why are we here? What's the meaning of life? And so forth. And the idea that certain ideas, because of the fact that they invoke the supernatural, will be off limits, potentially could impede that progress.
Thank you for that. Now, I know you've been very active on this issue, on the issue of Section 296. Are you aware of any group that has any objections to the removal of Section 296?
I originally intended to speak mostly about 296, but then I noticed that I couldn't find a single objection. That wasn't the case with 176, so I decided to address that a little bit more. But 296, at best I can tell, at least within the House of Commons, it appears to be unanimous support.
No, but you haven't heard from any other stakeholders? Or
No, not religious groups or anything that I could find with my research. So.
Okay. And we've heard from other people here today their misgivings about repeal of Section 176. Mm-hmm. My colleague, Mr. McGregor, actually spoke about how Section 176 could undermine Section 15 of the Charter, the equality rights. What is your opinion on that specific issue?
Interesting. Well, I mean, essentially equality rights is that's kind of the mandate of our organization. We want to seek equal rights for all religious groups and non-religious people as well. So, there are, like as I outlined in my opening remarks, there are in subsection 1, it's worded in a way that kind of implies there's a bias towards one side. And the point I mentioned about the potential chill on free speech with subsections 2 and 3, that's unequal because you kind of granted it is a limited scope, but you're providing protection to religious dogma or orthodoxy in certain situations. So that is, by definition, a violation of equality rights.
And my last question would be to Mr. Simpson. Could you also talk about the intersection of Section 176 and Section 15 of the Charter?
Well, Section 15 of the Charter really allows, if you like, it's an equality section. 176 does not, in my view, in any way violate anybody's equality. And I don't see how it affects freedom of speech. We're talking about religious services. And churches and synagogues and all of the other kinds of religious places of worship are open, usually. They want everybody to come. So it's not like, a lot of meetings are safe. They're inside of buildings and so on. And it disrupting the service, not being allowed to disrupt the service doesn't mean you're not allowed to express opinions about the religion. It's just where and when you do it. Imagine, for example, if the religious service happens to be someone's funeral or wedding. I mean, people are gathered there, or it might just be Christmas midnight mass, but that has a lot of special meaning for a lot of people. There are times and places for everything, right? And the place for protest is not inside of a place of worship when people are there to attend service. I just think that's wrong. And I think that's why we need 176, 2, and 3, particularly. It doesn't take away anybody's equality. Nobody's trying to prevent anybody from expressing opinions, just not disrupting the religious services.
Yes, Bishop Gendron. Yes, I understand.
En fait, dans la présentation que j'ai
In fact, in the presentation I gave, I insisted on the fact that the person who is responsible for the community is not different from anyone else. We're talking, this person wants the good of the community and therefore wants this assembly of prayer. We are talking about benevolent actions, a benevolent purpose. These actions have an objective, and nobody else has the right to disturb these people who have all come together. A clergyman is there to serve the community.
Thank you, Chair. Mr. Oliver, I'm going to start with you, and I just want to continue on the subject that Mr. Ihasi brought up, just from the previous round of witnesses that we had concerning Section 15 of the Charter, the equality rights. I was making the point to the witnesses that, for people who aren't religious but may belong to an identifiable group, if they are going to a meeting and the person who is the leader of that meeting is obstructed from attending, are they not, suffering the same amount of harm, and are they being excluded? Because Section 176, for the most part, makes specific reference only to religion but not to other groups. Their reply to me was that it's saved by subsection 2, which, and I'll just word it, it says, everyone who willfully disturbs or interrupts an assemblage of persons met for religious worship or for a moral, social, or benevolent purpose is guilty of an offense. So I'm just wondering, in your opinion, is this entire section saved by that subsection 2, given that it does make an effort to cover other groups? I just want to hear your thoughts on that.
With respect to equality, it definitely is better. As I mentioned in my opening remarks, weddings and funerals, for example. Obviously, a non-religious funeral should get the same protection as a religious funeral, and presumably both fall under that category. With religious worship, it is a little trickier, I guess, because you are prioritizing, arguably prioritizing, sincerely held views simply because there's an invocation of the supernatural.
In your remarks, you made reference to the fact that Section 176 of the Criminal Code is a deterrent. I don't think many Canadians were well aware that this section even existed before this bill came forth. And I would just like you to expand on your remarks, because do you really think that specific sections of the Criminal Code are a deterrent by themselves, or is it more how the law is applied through case law and so on? What, in your opinion, acts as more of a deterrent? And what will be more effective?
Bon, j'espère de bien comprendre la question, là.
I hope I understood the question. I would say that, at least as far as I'm concerned, and as far as how I feel, there was a gentleman whose name, Viktor Frankl. Viktor Frankl. And the meaning is different for everyone. For some people, their meaning of life lies in their faith. But for others, their meaning in life is that life has no meaning. But everyone has the right to believe what they want. They have the choice to choose what they believe. And what they believe is their truth. And they have the right to share that truth. And that's why when we also talk about the moral and the social, those aspects are also important. As from the moment we gather, we can talk about gathering for religious freedom, for freedom of thought, for freedom of belief. it is important that these rights be protected. I'm sure that there's another way of protecting these rights, but 176 underscores this particular freedom. And I also believe that in today's world, given the surge of hateful acts, 176 is more important than ever. And that's why I believe it must remain. In a few days, someone just passed me a note to this effect. A letter will be signed by the conference, and also an ecumenical and interreligious letter bringing together all these groups, people of the Jewish faith and the Christians and Muslim faiths will all sign together in the interest of upholding 176. I hope I've answered your question.
You're the legal counsel. I want to ask you this question. Bishop Gendron argued that the other sections of the criminal code are incapable of providing the same level of protections. I'm kind of, going over this specific section because, as you know, at the latter end of the criminal code, under section 718.2, under the sentencing principles, judges are given a lot of leeway to either increase or decrease a sentence based on whether the offense was motivated by bias, prejudice, or hate based on a variety of factors. Why, in your opinion, because we can't just look at the criminal code just as it's written, we also have to look at how it's been interpreted and used in case law. So why, in your opinion, do those sections not work as well as 176? Just want to hear your legal opinion on that.
Well, I think there's a couple of reasons. 176, or rather, the main section you would use is 175, causing a disturbance. But if you read it, now one thing you could do is put sections 176, subsection 2 and subsection 3, I suppose, as part of section 175. I don't know. But section 176 is about creating a disturbance in a public place, and you have to do it by doing certain things. And it is entirely possible to seriously disrupt a religious service or one of these meetings without creating a disturbance as it's defined in section 176. I think it's also, though, important. I mean, for a long time, perhaps, we didn't have a lot of charges laid under this section because I think for the longest time, I mean, I grew up in Canada. I can remember when people had different opinions on religion, but religious intolerance just seemed almost to not exist. I think we went through several decades where arguably Canada was the most tolerant place in the world for different religious opinions. But unfortunately, things sometimes change. And although I think the overwhelming majority of Canadians are religiously tolerant, we've had a lot of hate lately. Muslims, of course, are the primary objects of hate. But it is, as the professor pointed out, Catholics and, of course, Jewish people remain targets of hatred. Why, I don't pretend to understand, but it's so. And I think it's not unimportant to say, look, we view as important the right of people to go to their place of worship and be free from being interfered with while they're there. In fact, it's hard to. I don't think you'll find anybody who actually thinks you ought to disrupt these things, but I don't think the protections are there. With the assaults, there are ways to deal with it. There's no question. It's less significant. Although, we have a section, for example, if a policeman's assaulted because he's at a hockey game and he gets into an argument or something, he's not treated any differently than a plumber. But if he's in the course of his duties, he is, and I think there's good reason for that. And I think there's a lot of good reason to protect clerics when they're in the course of their duties, because they can be, and I think of late, they appear to be special targets. So there's something to be said. Just because people don't know about the particular section, I do think most people know that it's illegal to disrupt a religious service. And if you take it out, maybe people will find out it's not.
Thank you very much. And we'll go to Ms. Khalid.
Thank you, Chair, and thank you, ladies and gentlemen, for your testimony today. Greatly appreciated. We've heard specifically with respect to Section 176 varying opinions about what the role of the criminal code is, whether this section is applicable in today's day and age or not, or are similar protections offered in other sections of the code. And one argument I find to be quite fascinating, and I'd like to get your opinion on this, Ms. Buckingham and Mr. Simpson, is that the criminal code, its objective is to deter members of the community to not do certain acts that are disruptive, et cetera, that are unlawful. And we hear that this section needs to stay in the criminal code because we don't want to send a wrong message. And we've also heard that there are other sections in the criminal code that would apply. Now, I'm kind of grappling with this concept. The criminal code's objective is to deter, to prevent, to keep the peace within our society. But does it also carry a value of policy, or I guess proactive deterrence in having such a section in here to let people know that, you know, even though there have only been 30 charges under this section, that this is not acceptable? If I can, Ms. Buckingham, if you want to go first.
Thank you. Well, first of all, I think it's important to recognize that Section 2A of the Charter protects religious freedom, and this is, I would wonder, how is Parliament protecting the freedom of worship to worship without this section there? Secondly, churches, it may be that the general public isn't aware of this section, but churches are aware of this section. And I am aware of churches that have been able to stop people from causing a disturbance or to limit what they can do by saying, you know, it is against the criminal law of Canada for you to come in and disturb this worship. You may stand outside, you may have a sign, you can't use a bullhorn, you can do this and this, but you can't do that and that. And so churches have used it, short of calling the police, in order to deter people from disturbing a service of worship.
Mr. Simpson?
Yeah, I think the professors put it quite well. And it also enables the police to come, even if a charge isn't laid, if the police can at least come and say, look, you're committing a crime, you get out of here right now, or that has real value. I would also add that part of the purpose of the criminal code is to correct. And that's why, even though charges may not be laid, if there is some kind of restorative justice thing done, if the person gets psychiatric assistance that he needs, that may be a benefit too, because part of the criminal code is to correct when there has been a breach.
Thank you. Ms. Buckingham, you had said that you had some recommendations with respect to Section 176 in your remarks earlier. Would you like to briefly talk about them?
Certainly, and it really is just changing the term clergyman or minister to religious official, which I think is the terminology that the Supreme Court of Canada has used in these situations, from celebrating. I think religious is a little bit more inclusive than divine service, and then changing him to him or her, because we know that there are female religious leaders, and so I think it's better to have inclusive language there as well. It's not really a large change, but I think it may send a good, inclusive, and diverse message.
Thank you. And I actually just want to share, a few months ago, I was having an interfaith dialogue with a group of clergymen, the broader definition of which, and we were interrupted by a number of people who wanted to express themselves, Mr. Oliver. They barged in and they said dirty so-and-so, so-and-so to the clergymen people, and I wonder now if this section would have applied in that instance. No charges were laid, but those are all the questions I have. Thank you.
Thank you very much, Ms. Khalid. Colleagues, we're already past the time that this panel was supposed to end. Does anybody have any really short and important questions they want to add? And if not, I want to welcome Mr. Falk back to our committee. It's not been the same without you, and we're thrilled to have you back.
Thank you.
And let me thank all of the witnesses from this panel. You were very helpful. Your testimony was very thought-provoking, and I want to thank each and every one of you. And Your Eminence, thank you for attending from far away.